Yes.
Lordship, I think you mentioned action number 3 for admission. Lordship, kindly discuss matter after 2 weeks on 5th of August. My clients are outstation clients. I need to instruct in academic concept.
Okay. The learned counsel, Mr. T, learned senior counsel, Mr. T. Massa, appearing for the appellant, raised for an adjournment on the ground that he needs to take some instructions. Heard Mr. So-and-so appearing for the respondents. The prayer is allowed. List this matter on 5th of August, 5th of August for admission hearing. Yes. Item number 22. You can do it after 22nd. After
Will be done on 29th.
29th. Okay. On the request of Mr. Appearing for the respondent. 29th. The hearing is adjourned today. Heard the learned senior counsel, Mr. T. Massa, appearing for the appellant. Release this matter on 29th July for hearing.
Yes. I should like to mention item 15, 16, and 17. I pray for 1 week, your lordship to file that as a mystery now.
15,
16, and 17.
16 and 17. 15, 16, 17, same order. You want to file affidavit in the position?
Yes, your lordship. The state is one.
The learned counsel, Mr. So-and-so, appearing for the state respondents, prays for some time to file the counter affidavit. Heard Mr. So-and-so appearing for the appearing for the petitioner. The prayer of the state respondent is allowed. Least up to 2 weeks.
1 week.
1 week.
2 weeks.
2 weeks. Okay. Okay. Least up to 2 weeks.
May it please your lordship. Lordship, I on
Yes.
behalf of the appellants in item number 20 seek an adjournment, your lordship, with the consent of the other side.
20.
20, your lordship.
You are for the appellant.
Appellant, your lordship.
Many times it is so that a appellant counsel, this is not the first time the adjournment has been solved. Every time the matter is fixed, the matter has been adjourned. So let's be a last chance, no further adjournment.
Okay. What is your name?
Lordship T. Kashyap,
The learned counsel, Mr. T. Kashyap, appearing for the appellant, prays for an adjournment on personal grounds. The learned counsel, Mr. So-and-so, appearing for the state respondent, has objected to it on the ground that several adjournments have been taken by the appellant. But after hearing both sides, the prayer of adjournment is allowed for the last time. List again on
Lordship 5th of August, your lordship, if I may pray.
on 5th of August.
5th of
On 5th of August.
No further adjournment.
March of
Okay, this is last time. I have already mentioned.
lordship. March of
Yes.
Purpose to mention item 8, Lordship. Lordship, I need to receive the report, Lordship. So, how do you receive the Lordship?
Receive report.
Yes, Lordship, on the complainants, Lordship. Notice has to go to the complaint, Lordship.
Notice has not yet gone.
No, Your Lordship, regarding intimation, Your Lordship. And last time the Supreme Court has given an order to receive the receipt of the pay, but I need to receive that.
Oh, it's the learned counsel, MS so-and-so, appearing for the state respondents. Or MS so-and-so appearing for the MS so additional PP. PP. Learned MS so the learned PP raised for an adjournment on the ground that she is yet to receive the report. Hard Mr. So appearing for the appellant. The prayer of the learned public prosecutor is allowed. When do you want it? Least after 2 weeks. Yes.
They also mentioned like complete dealership. This mathematical system to times for hearing.
For admission hearing.
Lordship, you said they will be days.
After 2 weeks, giving date is difficult. In all the matters they given. The learned counsel MSN so prepare for the state respondent. Praise for an adjournment. Hard Mr. What is your name? W. Marhu. APA for the appellate. The prayer of the state respondent is allowed. Least after 2 weeks for admission hearing.
Lordship would like to mention item 1, admission matter, Lordship. I am for respondent number 5, insurance company, Lordship. So on 17 June, the respondent number 6, that is Private Doctors Association, has filed an affidavit, Lordship. So we seek 2 weeks time to file the response to that affidavit filed by respondent number 6.
Respondent number
Where they have made a misleading statement of it. They have made a statement saying that they have paid extra of 50 crore. Lordship, I have the record with me, Lordship. This is purely a misleading statement.
You want to say something?
This your Lordships.
Oh, who filed the counter affidavit?
Respondent number 6.
Respondent 6.
Respondent number 6, Lordship.
Lordship, I repairing to be able to just looking to your Lordship, but issue your Lordship.
Okay.
Since she was informed that the respondents will be seeking that your Lordship. So she is responsible of your Lordship. Please, they may be for it to get them.
No, what reply you want to file?
Lordship, respondent number 6, the Nagaland Private Doctors Association has filed a list of hospitals and certain amounts. However, as per our records, Lordship, we have paid and we have procured the no due certificate from most of the hospitals. And further, Lordship, there is some reconciliation request from our own accounts end. So that's why my clients have specifically requested for 2 weeks time, and thereafter we will file a detailed reply, Lordship.
Okay.
Lordship, that aspect of the matter is a different issue. We are talking about their.
Because Lordship, if
you have made some wrong statements, they will have to show by documentary evidence that it has been paid.
The statement in the affidavit.
Correct, Lordship. In response to the affidavit filed by respondent number 4, we have submitted an amount which is 20 lakhs more. So my clients also need to reconcile. So that's why they need further time, Lordship. So that we don't file any affidavit.
They are making
My humble say, Lordship, 2 weeks time will be granted so that we can reconcile our records and we file a affidavit detailed one, Lordship.
How does it speak? Where's the question of the Lordship?
Some people.
How much you have paid?
Lordship, if may kindly fix it on because I will be personally coming down to Kohima to attend the hearing, Lordship.
Paragraph 5, Lordship. Paragraph 4. Yeah. Okay, respondent number 5. The last article, Lordship. That was filed on 1st of June 2026.
Affidavit of respondent.
Number 5. This purely a misleading statement of respondent number 5. First of all, we need reasons.
Is it the big one?
Well, it's a small. It's 4 pages. 4 pages. It's a small affidavit. 4 pages.
Filed by respondent number 5.
Yes, respondent number 5.
With the affidavit in compliance.
Affidavit of compliance, yes.
Filed on behalf of the respondent number 5.
They are saying it's an affidavit of compliance copy. The affidavit of compliance is a misleading statement. Course mechanic of the paragraph 5. Paragraph 5. What?
Yes,
We belong to the process.
yes, that file.
That while respondent number 4 requires this respondent number 5 to make a further payment of 17.7 lakhs. Actually, 17.50 lakhs question. It is hereby stated that respondent number 5 has paid additional amount of discrete crore without any documentary evidence also. It's just a blank statement.
20 crore 52,000 lakh.
Yes, 20 crore 52 lakhs. From where they are making this calculation, Lordship, it's not reflected in the portal. This portal, Lordship, we have extracted from the NHA, National Health Operating Portal. No reflection.
Lordship, in March this year, 2026, Lordship, we have filed a detailed affidavit mentioning that UTR should respect to particular payments made to each and every hospital, Lordship. Each and every hospital. The state has not yet responded to that because as per our records, Lordship, we have paid that the amount that is mentioned in paragraph 5. And further, Lordship, after filing of the affidavit, respondent number 6 has again come up with a fresh calculation. So that's why I am requesting some time so that we can reconcile with our records from the respondent number 4 as well as respondent number 6, and then we file an affidavit, Lordship. Because our paid claims affidavit is already on record. We have filed it in March.
Okay, let him do that because he wants to have.
Because our records are not reconciled, Lordship.
Okay.
The document.
The portal says something else. Our records say we have paid 20 lakhs more. However, respondent number 6 says ki 5 crores is still pending, Lordship. So give us some time. Let us reconcile and file a detailed response, Lordship.
Okay, what is your name?
Mr. A. Kakoti, Abhijit Kakoti, for respondent number 5.
The Learned Counsel, Mr. Abhijit Kakoti, appearing for the respondent number 5. While referring to paragraph 5 of the affidavit in compliance filed on behalf of the respondent number 5, has submitted that he needs some time to go through the record to ascertain the actual facts. You are for the petitioner.
I have the respondent number 4.
The Learned Counsel so and so appearing for the respondent number 5. 4 has submitted that the respondent number 6, the respondent number 5 has made some comments in paragraph 5 of the misleading statement. In paragraph 5 of the aforesaid affidavit, Mr. Kakoti submits that today he is appearing by video conferencing and he prayed for some time so that he can come down to Kohima personally to take part in the hearing of this matter. On the other hand, Mr.
And sorry, Lordship, appearing on behalf of educational.
Appearing on behalf of so and so, so and so, so and so. The Learned Counsel for the petitioner. Praise for an adjournment.
And this question. I'm going for respondent number 6.
RMS so and so appearing for respondent number 6. The hearing is the matter is adjourned today. When you will come to
Lordship
Kohima?
on 29,
On
29 July.
29 July. July. Release this matter on 29 July.
Lordship, in the meantime, the respondent file reply for additional.
The respondent number 5 has the liberty to file the reply in response, in respect of the affidavit filed by the respondent number 6.
I got to get the report. The document that
The learned counsel, Mr. So and so.
was on.
If we put the respondent number 4 has submitted a reply, what is this report?
Yes,
Has filed a report today, and that report shall form a part of this record.
Let a copy of that be served upon my local council, Lordship. Filed by respondent number.
A copy of this report shall also be given.
provided he comes here also, I don't know.
Oh, yes, Mr. Kakoti, when he comes.
Lordship, deeply obliged.
I have been committed to recommend for a criminal appeal, jail 15 months of the government has become process. This finding for this on the appeal here has been released prematurely. Your was last listed.
You don't want to proceed with the appeal.
So the appeal has become yes. So instead of that, if the matter can I be listed all the way or listed in the next DB next week.
Next DB.
I don't know. What should I get? Item 6 and 7.
Yes.
This solicitor is actually in this case, such if it can validly listed on 5th of August.
Who will appear?
Deputy Solicitor General.
Or Deputy Solicitor General. Mr. Santianger, the learned counsel for the appellant, submits that in this case, the Deputy Solicitor General of India shall appear, and therefore he prays for some time. The prayer, Mr. Santianger, is allowed. List on 5th of September, 5th of August. 6 and 7, same order.
I don't mind this. This is praise, this matter, academic is culture.
On the request of the learned counsel, MS Simpson, the matter is adjourned today. List after 3 weeks. Item number 5.
Yes, we cannot take up this.
We cannot take up. You give the order.
Item 21. List the matter before any other bench without one of us put my name.
21. No?
21.
For admission, item number 2.
Yes.
The prayer in this petition is already considered by the states and this review board. The petitioner has already been released.
That's it. So you want to withdraw it? Mr. Muazami, the learned counsel, appearing for the petitioner, has submitted that the state government has granted remission of sentence in respect of the present petitioner. Therefore, Mr. Jamir submits that he wants to withdraw this. Huh? Also heard Mr. So appearing for the additional advocate general. Appearing for the state respondents. Since the prayer of the convict has already been allowed, this PIL stands closed in disposal.
Item number 4.
Yeah, item number. What was the earlier item?
The earlier one was
Oh.
item 2.
What is item number 4? In item number 2, this is not PIL, read petition.
WP criminal.
That's lordship. Lordship and for the petitioner is lordship.
Yes.
Now, lordship on 24th of June 2026, lordship, then the time of motion hearing, this court has directed certain documents released before the Honorable Court to assist this court. Accordingly, I have found my petitioner to be lordship. Now, lordship, in this case, it's a simple matter, yet very crucial, because the issue pertains to road construction, lordship. Now, what the petitioners are asking from this petitioner herein is a tribal apex body of Jackson tribe, lordship of Nagaland. Now, what they are simply asking to this petition is there has been inordinate delay, lordship, in the construction of 2-lane road, lordship, Kohima disseminate road, lordship, particularly at package 2, lordship. Not concerned with other packages, because the packages, even package 5 is almost on the verge of completion, lordship. Now, the documents of the respondents, especially the NHIDCR, would show that, like, lordship, there has been excessively delay in the road construction, lordship. So here in lordship, the petitioners are very much concerned and representing the voice of the people, because these road, lordship, serve as a connecting road lifeline for 4 districts of Nagaland, lordship. There is Kifiri, Peg, Maluri, and another, lordship. And also, this is also an interstate road, lordship. Not only that, it is also connecting the international road to Myanmar, lordship. Now, due to the inordinate delay, lordship, what is happening in this case is that many people are suffering. Not only suffering, but it is also posing as a threat, lordship, because there are unprecedented landslides and mudslides and storms are just rolling down, lordship. So it is a humble prayer of the petitioners that this road project, especially more particularly package 2, may currently be monitored, lordship, by this honorable court. This is the humble submission of the humble prayer of the petitioners, lordship.
Where's the NIT? NIT is page 36.
Lordship, in my additional affidavit, lordship, I have enclosed it. No, lordship, initially the road, the project package 2 was sanctioned on 10th of March 2020, lordship. It's also seen in the page 9 of my additional affidavit, lordship, wherein the NHIDCL has, in the RTI response, clearly stated, lordship, that the project was sanctioned in the month of March 2020. And if you would see, lordship, from page 11 to 13 are the project sanctioning approval order, lordship, from the Ministry of Board.
The construction has not yet completed.
It is not, lordship. Not the latest report, lordship, on 14 May 2026. Even before the meeting of the District Planning and Development Board, the issue was discussed, lordship, because this is concerned, there is a lot of concern, lordship, Now, what has happened was the contractor for package 2 and 5 were called for presentation. Now, package 5 is shown projecting as completion of more than 90%, whereas package 2 was still projected to be showing at 41% lodging of physical progress lodging. Now, this is where lodging, in fact, lodging, interestingly, on 19th of August 2024, lodging, NHIDCL, who is the respondent number 2 in this case, has already terminated the contract of the respondent number 7, lodging, who is the contractor. However, they still continue, but it is humbly clarified that the petitioners herein are not concerned about which contractor is executing the project. Their only concern is that it's already late, delayed, much delay has been caused. But it is also the concern of the petitioners that the project.
Respondent number seven already terminated.
So, Lordship,
Respondent number 7 already terminated.
it was terminated, Lordship, but termination letter was issued, Lordship. I have enclosed it on in my main petition, Lordship, starting from page number 43 to 58. This is a termination letter, Lordship, issued by the respondent number 2, Lordship, NHIDCL.
Now, who is executing the project?
It's the same contractor, Lordship. The same contractor, but like as I submitted earlier, Lordship, the petitions are not concerned. There must have been this termination must have been cancelled whatsoever. But Lordship, if you would see in page number 59 to 60, the contractor has written to the Deputy Commissioner, given assurance that by the 10th of June 2025, they will complete the road construction in the package 2. Lordship, it is in page number 59 to 60. Now, interestingly, even after the lapse of more than 12 months, there is no progress, Lordship. And this is the assurance. And if you see the project monitoring groups meeting, this issue has over and over again been emphasized, Lordship. And also what has happened, respondent number 5, who is the Deputy Commissioner of PEG, has also, and also the convener of the project monitoring group, has even written to the Commissioner Nagaland to terminate the contract of the respondent number 7, Lordship. Now, why all these things are happening is because of the inordinate delay. And if you see the project termination letter, there the NHIDC has listed the various reasons, Lordship. Wherein, as on 18, they state that as on the 18th of August 2024, Lordship, the physical progress, the milestone achievement stood at 0.30% physical progress and 0% financial progress, Lordship. So, Lordship, yes, NHIDCL has, in fact, the timeline, despite the assurance, the timeline was to be completed by 4th of January 2026 this year, Lordship. But that was also not achieved, Lordship.
Who is for the respondent number 2?
No, Lordship, this matter is yet, notice is yet issued, Lordship.
Not yet issued.
Yes, yes.
First of all, you issue notice.
Lordship, if notice is kindly issued, Lordship, then we will also take steps, Lordship.
Let them issue notice.
Lordship, yes.
And all the state respondent number 3, 4, 5, and 6. Then respondents here on 1, 2, and 6.
1, 2, and 6. Because NHIDCL is executing the work.
1, 2, and 7.
1, 2, and 7.
Yes.
So issue notice.
Yes.
Let us see what happens.
You're on, yes, supervisory meeting.
Yes, yes. Hard MS so and so API for the petitioners. Hard and additional petitioner.
Lordship,
API for the respondents 3, 4,
5, and 6.
5, and 6. Issue notice. No formal notice is required to be sent to the respondents 3, 4, 5, and 6. As because Mr. So and so has accepted notice. Who is for Union of India?
Lordship, union has been, arrayed as respondent one Lordship.
Somebody has to be there for union of India.
CGC is there.
CGC?
Yes, we made an attempt to serve copy, but we were informed that let the court issue notice first.
The petitioner shall take steps for service of notice upon the respondent number
1,
1 and 7.
1, 2.
1, 2, and 7. Extra copy of the petition shall be provided to the learned additional advocate general. The copy of the notice shall be served upon the learned CGC. Least after 4 weeks.
Lordship, also Lordship, if you would kindly allow me to take steps to dusting for respondent number 2 and 7, Lordship.
The petitioners are at liberty to serve the notice upon the respondent number 2 and 7 by dusting.
Lordship,
By dusting.
Lordship,
Least after 4 weeks.
right, Lordship.
For admission, item number 9.
Yes.
I inspired for conservation of 27 days delay in finding the company appeal.
Okay. 27 days. 47 days delay in preparing the appeal.
Excellent.
Only 47 days.
Any objection?
Do you have any objection?
Your Lordship, earlier, the office note shows that the appeal was filed on 9 March, 9th March 26. So if you count, it will be more than 47 days. However, they have given one clarification from the office note that it was filed on 9 February. So it comes within the limitations. So no problem.
We'll condone it.
We'll condone it. Hard have so and so. Appeal for the applicant. Hard Mr.
YP Gupta,
YP Gupta appeal for the
a special public prosecutor for respondent number 1 and 2, ED.
special public prosecutor. Appeal for respondent number 1 and 2. This application has been filed under section 42 of the Prevention of Money Laundering Act 2002, praying for condonation of 47 days of delay in preferring the connected criminal appeal. There. Mr. Gupta has Gupta. You are Gupta.
Yes, YP Gupta.
Mr. Gupta has submitted that he has no objection if the delay is condoned. We have also found that the delay has been satisfactorily explained. Therefore, the delay stands condoned. The connected criminal appeals have been registered and listed for admission hearing. The ISLs disposed of accordingly.
Obliged, Your Lordship.
For admission, item number 10.
Who is for the respondent?
For the state of file, your worship.
But there is an office note here. 17/06/2020, counter affidavit not filed by respondent.
Union of India.
Maybe Union of India.
Maybe Union of India. Who is for the Union of India?
This hearing is arranging the application order dated 27 October 2022. The confirmation order dated 28 January 2022. And the order dated 28 April 2022. My lord, the fifth case of the case of the Lapaya was dated 30 January 2022. Stating that the railway police, during meeting, taking arrested the present.
You are for the Union of India?
No, I'm fine for the issue.
No, you are for the Union of India.
Yes,
You have not filed the counter affidavit.
my lord, I
Let him file the counter affidavit. After that,
filed the bureau.
Hmm?
You have filed today.
Oh, today.
Yes. I didn't get it by.
Oh. The learned counsel, Mr. So-and-so. You are CGC.
Yes, ma'am.
The learned CGC, appealing for the Union of India, has submitted the counter affidavit today only. Have you gone through it?
My lord, I have no allegation against the central.
Okay.
They heard today.
No,
No
it will-
allegations against the state.
it will go for hearing. It will need a little bit of hearing. No? The next item. After 2 weeks, we will hear
My lord, in 1 week.
uh,
Yes.
list matter next week for hearing.
This one is 16.
The item number 16 is also same.
It is 16. This one is
Yes,
15.
my lord.
This is item number
15.
15
Item number 12.
or 12.
WBC was 15.
No, you have filed in WP criminal 16 or 15?
15. I didn't press that.
Oh, 15 already filed.
Yeah.
Oh.
Or already filed. Then item number 16, 13
Item number 13, I have
today.
today.
The same order. Same order. Next week.
My lord.
For admission, item number 18.
Yes.
Ladies and lordships.
Hmm.
Last order, lordship, this order the board was directed, service notice was awaiting, while directing the registry to,
Hmm.
check up the process whether the respondent will.
The postal tracking report shows the item in tracking report is marked. The tracking report item invoiced to BO. Already it is served. Is it served? Is it served?
Precaution for register, I don't understand. I don't
Ah, I
know what's
don't
the
understand.
appeal. Although they say delivered. But
What is BU?
Learned Council, have you seen this? The tracking report? Just go through.
What is this BO?
What is BO?
I also don't know.
No one,
I'm not.
no one knows what it is.
Uh-huh. Postal bill. You found it. POSOHO.
Branch office.
Branch office. Oh.
So it has not reached, that means
Hmm.
it has.
Not yet delivered.
Not yet delivered.
You have
In
to-
that case, can it be published in the newspaper?
It can be done. It can be done.
No, she.
No, it can be done. It can be done.
Yes, in your own experience.
Seen the office note dated 25/06/2026. MS Jed Jimoni. The learned counsel for a petitioner submits that she would take steps for service of notice upon the respondents by public
Respondent number 7.
respondent number 7.
No, 5.
Respondent number 5.
5.
Respondent number 5 by publishing the same in a local newspaper. Hard Mr. So-and-so appearing for the appearing for the state of Nagaland. The prayer of MS Jimoni is allowed. The notice shall be published in a local newspaper on
Within,
the month of July.
just logic, within a week, within a week.
Within a week. And this matter shall be listed after 1 week.
Much.
Herein, item number 19.
What about your supply list? Supply list.
Yes.
And the last few occasions, townships, in view of paucity of time,
Yes.
better potentially taken up.
Hmm.
In view of the fact that there were 14 litigations, but so far as issues involved in this case is concerned, is very short and simple also. So before I build into the detailed facts, just a summary, so as to get the claims about the nature of the case and the issues involved in the case. This is a case from the Nagaland Legislative Assembly Secretary. The present petitioner, who is the appellant, is in the rank of additional secretary, and the respondent number 4 has been promoted to the post of secretary. and the petitioners agreed by the promotion of the respondent number 4.
Yes.
What happened is, Lordship, in 1996, on the basis of a selection process, both the petitioner as well as the respondents were selected. So far as the selection process is concerned, it is through an open advertisement, and both of them were appointed on the basis of the same selection process. Petitioner was appointed to the post of Assistant Research Officer, and the private respondent was appointed as Assistant Transport Officer. Now, so far as the petitioner is concerned, she has been promoted, put her ladies, Lordship, so it will be more appropriate to use she and her. So, the lead petitioner has been appointed from time to time to different grades in accordance with the provisions of the service law. And her last promotion was on 30th November 2019 to the four-star additional secretary. That promotion was given after the case was considered by the DVC, Departmental Promotion Committee. So far as private respondent number 4 is concerned, she was appointed and posted as Assistant Transport Officer in the same secretariat, that is a branch. And next promotion was to the post of Transport Officer. She was promoted. And her promotional avenue is only up to the rank of Transport Officer. Beyond that, there is no promotional avenue for respondent number 4. Therefore, in view of that situation, she was upgraded the post which respondent number 4 is holding has been upgraded from time to time. And it so happened that if I'm promoted on a particular date, on the same date or next day, the respondent number 4 will also be upgraded to an equivalent post. And as many as 5 upgradations were made in respect of the respondent number 4. Last upgradation order was to the rank of additional secretary. Till that time, and in all the upgradation order, there is a clear stipulation in the order that the upgradation is personal to the incumbent. When it is earmarked a post personal to that person concerned, we are not entitled and eligible to go there, nor she can also come. That is the situation that was prevalent for a long time, up to the rank of additional secretary. Petitioner happened to be in the general cabinet, so her promotion was in the substantive sanction post, up to the rank of additional secretary. And in that post, one day she was ahead of the respondent number. But then all the upgradation orders of the respondent number 4 has been done personal to the incumbent. And the last upgradation order which says that the moment this post is vacated, the post will go back to the post of transport office. That clear stipulation is there in the order itself. Now, what happened? In the rank of reaching the rank of additional secretary, the respondent number 4 wanted to come to general cabinet. Therefore, an order was issued on 1st of November 2021. Notification dated 1/11/2021. By that notification, the respondent number 4, who was holding a post personal to the incumbent in the upgraded post, has been brought to the general cabinet. That came to be challenged by 4 petitioners on the ground that look, she is holding a ex-cadre post. She is not in a cadre. So her engagement to the general cadre is blocking our promotional agreements. Therefore, this is illegal. On the same day, that is on 1st of November 2021, a memorandum, office memorandum was also issued at the same day in respect of respondent number 4, by which she was regularized in that upgraded course of petitioner secretary. So, 4 petitioners challenged that in WPC number 323 of 2021. And this WPC 323 of 2021 came to be decided on 12/5/2022. And the ultimate direction and finding of this honorable court is in WPC 323 of 2021 is that the notification of 1st November 2021 has been quashed, by which the respondent number 4 was brought to the Telegram and the office memorandum of 1/11/2021, by which she was regularized in the rank of additional secretary, was also quashed. This was not challenged by the respondent number 4. Now, while disposing of that WPC 323 of 2021 on 12/5/2022, a writer was mentioned by the honorable court to the effect that although these notifications are quashed, if the respondent authorities, that is the assembly, if you want to do restructuring of the garage, then that may be done, which can be done in accordance with law. So, taking advantage of that observation, other part of the judgment was not challenged. It was accepted by all. Now, the respondent authorities, taking advantage of that observation, granting liberty to them to amend the service code within 5-6 days time on 22/5/2022. Judgment was passed on 12th. And on 18 May 2022, rule was amended within a period of 6 days by applying different technique. They have amended the service rule within 6 days. This was happened in a time when a cadre review committee was already pending in the Nagaland Legislative Assembly to restructure the cadre. It was pending. And this is a time when there was an officer above all of us. That is, there was one commissioner and secretary by name Anthony, Teacher Anthony, Lordship November May. Know that. He was the person who was brought from Lok Sabha anti-petition as the secretary, and thereafter he was promoted to the post of commissioner and secretary. He was managing the post after. So within 6 days, the rule was amended on 22nd May 2022, making some changes. Major changes are about 3 points. One, the appointing authority for appointment of the employees of the Assembly Secretariat was only the Speaker. But appointing authority was made to be the Governor, so far as Secretary is concerned. It will be appointed on the recommendation of the Speaker by the Governor with fair consultation with the Chief Minister. That is one. Another aspect which is very important and relevant for us is, the rank of Joint Secretary, there should be no interchangeability of the header, and there can be no interchangeability of duties and responsibilities below the rank of Joint Secretary. Additional Secretary above, there can be no distinction of cadre above Additional Secretary, and there can also be no bar for assignment of duties to above the Additional Secretary. So that was the amendment, the effect of amendment. Now, this amendment came to be challenged by the Association of the Nagaland Legislative Assembly's Employees Association. On the ground that look, while disposing of the writ petition, that is the WPC 323 of 2021 by this Honorable Court has said that you do it in accordance with law. So, what is the law? Law says, even a person can be retired on attaining 37 years rank of service or 60 years free service period. In respect of the Commissioner and Secretary, Anthony, it was made 65 years for his retirement. So it is not in accordance with law because it is in violation of Nagaland Retirement from Public Employment Act. That is one of the grounds. Secondly, therefore, this law has been passed just in order to circumvent the order passed by this honorable court because respondent number 4 wanted to come to the cadre because she was holding an ex-cadre post personal to the incumbent. That is what the legislative judge has directed of it. But she still wants to come. So how to come to the general cadre? That was the motive. So we association challenged that. This is not in accordance with law. This is just in order to circumvent the order. Therefore, it is not in accordance with law. So there are and the review committee which has been constituted by the assembly to restructure the header. You could have at least revived this and then entrusted this matter to this committee, which is already pending. Alive. But then by passing all this, it was done only in a secretive manner. That is why the association has challenged. No state, but petition was pending. During the pendency of the petition, what happened? On 5th July 2022, the private respondent number 4 was given current charge to the post of secretary. And there is another episode here in the middle. Above us, there is one commissioner secretary. All the employees of the Nagaland Legislative Assembly were against that person because he was brought on petition and directly appointed to the post of secretary. So the cadre officers and the employees of the assembly who are to occupy that post is being blocked. So there was serious agitations from the employees. He resigned and ultimately he left. Well, we could manage to succeeded to expel an outsider. Now the fight comes within our own house. Among the employees in the assembly, this has happened. So, as I was mentioning about the earlier challenge to the service law, it was pending. But then the current charge was given to respondent number 4. So, the present petitioner appellant has challenged that temporary current charge order on the ground that look, even for temporary current charge, seniority should not be ignored, and I am the senior most in the general cadre who is eligible to be considered for a post of secretary. Therefore, I should have been considered instead of respondent number 4. Even for current charge, that was the plea taken by the deputation. Interim order was passed. Against the interim order, the private respondent number 4 came. And then interim order was ultimately came to be vacated. Therefore, against the vacation of the interim order, a writ appeal was filed. That is writ appeal 28 of 2022. A writ appeal was filed challenging the order passed in IA 116 of 2022, which was passed in the VPC number 114 of 2022. Now, the vacation order was again challenged before the appellate court. Appellate court, after hearing the matter, arrived to a conclusion that, look, it is only a temporary current charge. Therefore, there is nothing wrong to allow respondent number 4 to hold the current charge. And then the appeal was dismissed. However, an observation was made while disposing of that case to the effect that, however, the respondents are directed to fill up the post of secretary without delay in accordance with law. Therefore, whatever may be the observations and discussions that may have taken place in that date April 28th of 2022, that is not an issue. Who is eligible, who is not eligible. That was an issue against an interim order. It was passed in an IA. It was not an issue. Who should fill up the post of secretary? Actually, who is eligible or not? That was not the issue. Therefore, the ultimate direction of the court, this honorable court, was by the division bench. We would not have done this when the writ petition, where the rules have been challenged, amendment of the rules have been challenged, is pending. You could not have done this, but you fill up the post of secretary at the earliest in accordance with law. That was the direction given. Thereafter, nothing happened for the last 2 years. Because the delay of 2 years may be to make the respondent number 4 to make her eligible to consider for this post. Because 2 years is required. And if counting from the amendment of the service law, it was on 22/5/2022 only. Therefore, she will not complete 2 years time. So maybe those were the reasons why it was delayed. Anyway, that is the repeating. Now, on 6th of March 2026, the respondent number 4 was regularized in the post of secretary. The present petitioner, who is ready here, has challenged that on the ground that look, the respondent number 4 is holding an ex-cadre post. She is not any cadre. All throughout her service career was through upgradation. Personal to the incumbent. And on the day when the parent charge was given by order dated 5/7/2022, she was holding a post of additional secretary with a condition that it is personal to the incumbent. And the moment that she begins the post, it will be reverted back to the post of transport office. Therefore, even if the third amendment says that there can be no distinction of cadre above the joint secretary, there is distinction among us. Why? She is not equivalent to me. I am additional secretary. My promotion has been considered by the DVC, and the promotion order has been issued in accordance with law. But so far as respondent number 4 is concerned, she is still holding a substantive post of transport officer. And all other posts up to the post of additional secretary and secretary, personal to the incumbent only. Therefore, she is not holding an equivalent post. She is not holding a substantive sanction post. Therefore, we are not equal. We are different. That is how I have challenged this. What happened, Lordships? The matter was listed on 21st of March. Order was passed on 6th March 2026, and the matter was listed on 21st March 2026. And that day, both the councils who are representing now, although no debate was filed that time, they appeared without appearance and made a submission that I want to produce there. It was on 26th of March. However, on 25th March, there was already an order which was not placed before the Honorable Court on the next day, that is 26 March 2026. And the council has appeared on instructions from the client. Otherwise, without instruction, nobody can appear. My question is, that is in the last writ petition. Look, when the matter was listed on 25th March 2026, 26th March, you are already aware about the order of 25th March 2026, but you have not placed this. Matter came to be listed again on 30th. That is as per the instruction of this Honorable Court, direction of order passed by this Honorable Court. And they have placed that order before the court that it is already modified. First order, which was passed on 6 March 2026, was regularized in the post of secretary. On 25th March, was the Indian order, which is the Indian order now. That order has modified. A modification order is a promotion order. Sometimes they are saying it is regularization. Sometimes they are saying it is promotion. Same post. A person who is holding a ex-cadre post, who has not been engaged yet. And all the accreditations were personal to the incumbent till the last one. So that is the, sorry, let me come to the finding of the resolution. Let us go to the character of finding that look, it is rule 12 of the service rule, which applies, but not rule 15. Rule 15 is constitution of TBC, and all cases of promotion shall be done by the TBC. That is the service rule. So we are saying that, look, the respondent rule 4 has not been promoted by a two selection process, that is by TBC. Because rule 15 clearly says all cases of promotions and selection shall be done by TBC. And the schedule also, it is very clear that it will be by additional secretary. So to promote to the post of secretary, a person should be holding a substantive post or in the rank of petitions. That is all. And she is not holding that post. So I should have considered for promotion. So that was the thing, but the single judge came to the conclusion that no, as per rule 22 should be read in isolation with rule 15. Rule 15, otherwise, rule 12 will be redundant. That was the submission. That is your own theory. And the post of secretary is a selection post. Service rule nowhere says that the post of secretary is a selection post. But during the course of document, the council for the respondent number 1, 2, and 3 has categorically submitted that it is a selection post. So TBC is not required. That was the submission. Then the single judge was convinced by the submission, which was their own theory, which was amended, and the learned single judge was convinced by that theory and came to the conclusion that TBC is not required for the promotion to the post of secretary. It is because junior officers cannot assess the senior officer. That was happening. I will come to the rules, what the rules is. So that is one of the main points where the learned single judge has gone wrong. I should say that it is not in accordance with law. Therefore, the learned single judge has ignored the provisions of the rules. So that is one. The other aspect is some reliance that are met in the earlier judgments, but as I was submitting earlier, in the writ appeal 28 of 2022, that is only with regard to the interim direction and vacation, which was on the issue of temporary current charge, given the respondent number 4. Therefore, if any observation is made or discussion is made, and that is by the division bench, because there are two division bench judgments here. One is dismissal of the challenge to the amendment of the third amendment. Okay, we're accepting that. But now, what the law says will have to be decided by this law. That is one aspect. That is the issue of challenge to the service rules. The other aspect, that is the division bench, because there are two division bench work, which is passed in the writ appeal 28 of 2022. That is in an IA, where the issue was with regard to the temporary current charge. And it was an issue of passing of interim order, application of interim order. But ultimately, even in the writ appeal 28, this honorable court, the division bench said that there should be no delay in filling the post of secretary in accordance with law. Whether 2-3 years delay can be considered as a delay or not, that is, I leave it to your lordship. But then that was the direction. And then the present two Indian us. Now, I would like to come to the documents. Only the relevant documents and the relevant portion I would like to
And
read.
during these 2 years,
Otherwise,
learned counsel, during these 2 years, the respondent for was continuing on current charge.
yes, correct. But page 76. I will just refer only to show that how appointment was made, what was the last promotion of page 76 of the memo. This is the initial appointment order. 30th September 1996. And is it is with effective from 2nd September 1996. And next page 77, that is connection B. Other promotions are not relevant because that is why I have not imposed. Last promotion order. I may be allowed to read this. This is 30th November 2019. In exercise of powers vested in him under Rule 12, Clause 2 of the Nagaland Legislative Assembly Secretariat, Recruitment and Conditions of Service Rules 1999, Second Amendment Rules 2012, included, and on the recommendation of the Departmental Promotion Committee, the Deputy Speaker in charge, Nagaland Legislative Assembly is pleased to promote Srimati Janenda, Joint Secretary, to the post of Additional Secretary, Class 1 Candidate, Sponsor, Biometrics and Identity, and all other allowances admissible under the rules from time to time, with effect from the forenoon of 2nd December 2019. This is the promotion order, last promotion order of the petitioner appellant in the rank of Additional Secretary. This is a proper promotion order which was given on the basis of the of the Departmental Promotion Committee. And this order was issued under Rule 2, Sub-Clause 2 by the Speaker. When the authority was the Speaker. And this appointment has been made on the recommendation of the DBC, the promotion orders. So here, I would like to emphasize one point. For promotion to any post, first, it has to be considered by the DBC. On the recommendation of the DBC, it will be appointed by the opinion. Promoted or appointed. So my promotion order is perfectly in accordance with. So I'm submitting that the respondent number 4 promotion should happen in this manner because we were promoted on the same day. That is 30th November 2019. So Rule 12 and 15 should be read harmoniously. After rule complying with the Rule 15, Rule 12 will come, that is the appointing authority. But to appoint or promote, first, Rule 15 has to be complied with, that is the DBC. And in respect of respondent number 4, no DBC was considered. That is how it works. Right? In terms of the service rule, the promotion should have been considered. And I have a right to be considered for a promotion. That was my. Now, can they come to the appointment of respondent number 4, page 79? I am referring to type copy only. Because it is slightly here. Mayor Pro-Chiefs, in exercise of powers vested in him under Rule 12, Clause 2 of the Nagaland Legislative Assembly Secretary, Recruitment and Conditions of Service Rules 1999, Second Amendment Rules 2012, incorporated. Deputy Speaker, Speaker in charge, Nagaland Legislative Assembly is pleased to appoint. It is appointment. In respect of petitioner, it is promotion. But in respect of respondent number 4, it is an appointment. Appointment Chairman so-and-so, Joint Secretary Transport, against the upgraded post. This is important also. Of Additional Secretary Transport, Class 1 Gazette, personal to the incumbent. This is also important. Upgradation is personal to the incumbent in the day of so-and-so. And the last paragraph will be relevant again. Third paragraph, that is the last paragraph in the order. The post will automatically stand reverted to its original post of transport officer as and when the present incumbent vacates the post. So this clearly shows that the respondent number 4 is not holding a substantive career post. It is upgraded personal to the incumbent. So when it is earmarked for a personal to the incumbent, I cannot go, she cannot come to us, and we cannot close. And the moment it is vacated, it will go back to the post of transport office. Very clear. And till the 7th July 20, from 5th July 2022, current charge was given. And this was the order, last order. Besides this order, after this, there is no promotion order, there is no regularization order, there is no absorption order. Therefore, on 30th November 2019, the respondent number 4 was holding a post personal to the incumbent in an upgraded post in the rank of additional secretary. And the moment that is vacated, it will revert back to the post of transport. So she was not holding a substantive career post at that relevant time when she was given current charge. Even on the day of promotion, she was not doing this. She was holding this post on the basis of this order. Kindly come to page 121. I will jump for a moment because to show the connectivity of this. As I was mentioning, 121. The then single judge passed the order in PVC 323 on 12 May 2022. Within 6 days, they could amend on 18 May 2022, and this order is 30 May 2022. The implication of this order is they have revived the order of 30th November 2019, which I have been referring to your lordships at page 79. This is 30th May 2022. This order has been issued after amendment of the service rule, because service rule was amended on 18 May 2022. Second paragraph is very important in this order dated 30th May 2022. Respondent number 4 has accepted this order. She has never challenged this order, by which the order of 30th November 2019 was revived. That means she was holding a ex-career post, a post personal to the incumbent. So in view of this order, the respondent number 4 is still outside the general category. Therefore, we are not equivalent. Rule permits to promote to the post of secretary from the rank of additional secretary when it is equivalent equivalent. But in view of this order, since she is holding a post in the rank of undersecretary, transport officer, a subordinate post, transport officer is equivalent to undersecretary in the general care. So there is no valid promotion order except accreditation from the post of senior officer up to the rank of additional secretary. No promotion order, no absorption, no regularization, only accreditation pursuant to the income. So how can it be relevant, equivalent with? Now, up to page 79, can we come to page 80? Because unless I refer to this, there will be some missing link. That's why I want to go systematic approaches. This is page 80, 1st November 2021. This is an office memorandum by which she was, respondent number 4 was brought to the general cadre by incorporating in the service role, and it was inserted in the third schedule. And Lordship will find in the last paragraph a reference of the High Court order will be found. This last paragraph, this issues with the direction of the Honorable Gauhati High Court, Kohima bench, in WPC number 20 of 2021, dated 14/7/2021. So, pursuant to the order passed by this Honorable Court on 14/7/2021 in the WPC number 20 of 2021, this order was passed. That is what they are saying. So, this order will also, Lordship will find at page 315. 315. This is a case where the petitioner has submitted the representation. Representation was pending, but then it was not considered. So the direction was issued by this Honorable Court to dispose of the representation of the petitioner with the evidence. That was the only direction. In what manner it has to be done, how, whether it should be engaged or not, nothing. Only directed to consider the representation. But that will not be relevant because of the fact that this order has been quashed by the Honorable Court. By this order, office memorandum, she was brought to the general cadre, and by the next order, that is in page 81, Annexion E. This is a notification issued on the same date, that is 1st November 2021, by which she was regularized with effect from 29 November 2019. So both these notifications were quashed in the WPC 323 of 2021.
Which notifications? 1st November 21, two notifications, no?
Yes, page
OM and
1881.
1881.
Yes. One is office memorandum, first one, and the second one is the notification. First one order is the engagement to the general cadre, and the notification is regularizing her service to the rank of additional secretary. Both the notifications and office memorandum were quashed. After quashing these two orders, the 30th May 2022 order has been passed. The order passed by this Honorable Court, also finding page 52. This was passed on 12/5/2022. And the finding, I will just take the lordships to the relevant portion where the finding has been arrived. Paragraph 25, page 110. Page 110, paragraph 25. This is the operative portion of the order. May I read this paragraph or
Paragraph 35.
Paragraph 35, page 110. Therefore, upon your consideration of the matter in its entirety and the findings arrived at the preceding paragraphs, it cannot be said that the rights of the respondent number 3 has crystallized in any manner or that she has accrued and acquired a vested right under the rules of 1966 or the rules of 1999. Therefore, the case of the Kiraj versus Sabra and the case of Cheese setup are found to be not applicable to her case, and moreover, the effects and circumstances involved are also not similar. In the result, the Imperial Office Memorandum dated 1/11/2021, that is page 80, and the Imperial Notification dated 1/11/2021, that is page 11, are found to be page 81, are found to be unsustainable and are hereby set aside. However, because we have amended the rule based on this stage, however, at this, the same shall not be debarred the respondent authorities concerned from considering the restructuring of the various posts under the Assembly Secretariat, which should otherwise only be done in accordance with the relevant provisions of law and by taking into consideration the rights and interests of all the stakeholders. So this was the direction. So the Assembly Secretariat Association has challenged, though this Honorable Court has also directed to take into consideration of all the stakeholders. Why you have not consulted us or we were not invited us for amendment of the restructuring of the service? That was the case we have agitated by challenging the service code, amendment of the service code. Because this Honorable Court has clearly mentioned that taking into consideration of all the stakeholders means the employees of the Assembly Secretariat are stakeholders. So we should have been consulted. We have not been consulted. Within 6 days, the law has been amended. And this amendment is just an effort to circumvent the court order, to avoid the court order and to do whatever they feel. So under the law, we have challenged this amendment of the service code. However, that is only academic discussion. That was dismissed. So ultimately, what remains? The third amendment, what the third amendment says will be delivered. Because the challenge for the amendment has been quashed. Now, when we come to the amendment, the petition was disposed of on 12 May 2022. Amendment was made on 18 May 2022, after 6 years. Page 115 is the type copy, which is more clear.
Page
115. Since we will be revolving around this amendment, I think it will be relevant to read. There's only 3 pages.
Yes.
18 May 2022. In exercise of powers conferred under Clause 3 of Article 187 of the Constitution of India, the Governor of Nagaland, in consultation with the Speaker of the Nagaland Legislative Assembly, hereby makes the following amendments in the Nagaland Legislative Assembly Secretariat, Recruitment and Conditions of Service Rules 1999 as amended in 2012. Short title and commencement. This amended rule shall call the Nagaland Legislative Assembly Secretariat Recruitment and Conditions of Service Third Amendment Rules 2022. This rule shall be deemed to have come into force with immediate effect. In Rule 6, Para 2, the words for a period not exceeding 3 months shall now be read as for a period not exceeding 6 months. 3. Rule 9 shall be replaced as follows. This will be relevant motifs. Recruitment to the post or class of post may be made by any one of the following methods, namely, earlier there were only 3 methods of recruitment, that is A, B, and C, by promotion, by intimidation, by direct recruitment. But by the amendment, D has been inserted by short-term contractual engagement. So, for the post of secretary, there are 4 channels of sources of appointment: by promotion, by intimidation, by direct recruitment, by short-term contractual appointment. Last 3, B, C, and D, we are not on this, but this is possible under the provisions of the service. So, in case of direct appointment, selection will be done. It is a selection course. How? They can be selected. Secretary can be selected out of your benefits. In that context, selection will be relevant for contractual appointment, for intimidation, for intimidation, by direct recruitment, by short-term contractual engagement. 3. So, for direct recruitment also, I believe just from the street you cannot choose. Advertisement will be there, application shall be invited, in which case it will be selected. So selection is relevant in that context. But for the serving employees, how the post of secretary is to be filled up? It is to be filled up by promotion from the rank of additional secretary who has completed 2 years of continuous service. And when we come to paragraph 4, that is last paragraph in the page, in rule 10, under the caption, streamlining of existing error, the existing clauses A and B are replaced by the following. And then these 2 clauses, new clauses have been inserted in page 116, Article 5, A and B. As I was mentioning, there shall be no intertransferability between the cadres schedules up to the rank of joint secretary. We are not concerned on this. B. There shall be no distinction of cadre. Distinction of cadres. Cadres should be noted. Above the level of joint secretary in the assignment of duties, distribution of work, and all other service matters. All are governed. See the motive. How they are amending the service. So, above the joint secretary, there can be no distinction of cadre. So, the respondent number 4 should be holding a cadre post above joint secretary, additional secretary and above. Then only it can be interchangeable. Otherwise, no. This is what rule says. Paragraph 5. Rule 12 under the caption appointing authority. The existing short rule 1 is replaced by the following. The secretary and additional secretary shall be appointed by the governor on the recommendation of the speaker in consultation with the chief minister. So this has been inserted, and the condition of the respondent number 1 to all the respondents is that it is rule 12 which is applicable for promotion or appointment for the post of secretary, and rule 15 is not applicable. That means TBC is not required. That was the condition they have met. And that was accepted by the single judge. That is how we are agreed. Then, just add this one. Paragraph 6. A. Under Rule 15, paragraph 4, serial number Roman 4 is modified as follows. And then annual increment, all this, annual assessed appraisal report, all this, we are not concerned with this, so it is not relevant. But in page 117, on the top, Lordship will find that this is typo. In third schedule, under caption B, page 117, In third schedule A, against schedule number 1, column 7, the following shall replace the existing entry. And then it is mentioned as by promotion from the grade of additional secretary or equivalent in the assembly secretary with a minimum of 2 years of continuous service in the grade if deemed fit by the appointing authority. So this is the amendment. And after this amendment, as I was referring to page 121, after this amendment, page 121, 30th May 2022 order was issued, by which the 30th November 2019 order has been replied. This order has been issued after the amendment of the service. So even after amendment of the service code, the respondent number 4 was holding a post, substantive post of transport officer, although upgraded several times, personal to the government. That is very important. Therefore, when it is personal to the incumbent, we are not equivalent. We are not same. I cannot go, she cannot come. But all the courts thought that she was made eligible by third amendment. No. That is how there are serious implications arising out of this. And then after the amendment of the rules, the petitioner has submitted a resolution to consider her case, but that was not done. And then kindly come to page 122. This is the challenge to the rules by the Nagaland Assembly Secretariat Staff Association, in short, NASA. This was decided on 24 April 2024, by which it was dismissed. That means the third amendment shall be valid and it shall remain. So, what the third amendment says will be relevant. But some operative paragraphs I would like to refer here, because the respondent on the last occasion has also argued based on these observations. Page 150. Paragraph 40. And as a lordship, yes. Page 150, paragraph 40, what you will find in the bottom. The other ground is with regard to the challenge to the amendment of the Rule 10 by amended rules of 2022. What we have noticed is that by amendment of Rule 10, the respondent had created a meeting point of different cadres at the level of joint secretary so that there is promotional avenues for all the wings. The rules of 1999 precludes certain wings for further promotions beyond that particular post. However, by the amended rules of 2022, a level playing field has been created from the level of joint secretary by providing an opportunity to all the members of the Nagaland District Assembly Secretariat, irrespective of the wings to which they belong, to be considered for promotion. Therefore, by providing the level of playing field for all the wings, we see no reason to interfere with the amendment of Rule 10 by the amendment rules of 2022. And then case reference has been made. The level playing field for different cadres have not conferred a special right to the respondent. That is my summation portion. This Honorable Court, the division bench, while deciding on an issue of amendment of the rules, the division bench has arrived to a conclusion that the amendment has just brought a level playing field for all the employees. So it is natural. And the respondent number 4 presumed, and for that matter, respondent number 1 and 2 and 3 also presumed that this has conferred a right to respondent number 4 by the division bench. And we put a single page. If I show all these things, they are pending. There is no specific finding conferring right to any officer by this observation. And then paragraph 41. Paragraph 41 and 44 only, I will read only these two paragraphs. Paragraph 41. Further, challenge has been made to the amendment of Rule 12 by the rules of 22. However, the same pertains to the appointment of additional secretary to the by the governor under recommendation of the speaker in consultation with the chief minister. We see no reason as to how the fundamental and constitutional rights of the petitioners are violated by the said amendment. And then just jump to paragraph 44, the operative portion. In view of discussion made herein above, we are of the considered opinion that the present petition is without merit both by way of intentionality and on merits of the case. Accordingly, the writ petition is dismissed, however, with no order as proposed. This honorable court, the division bench, has only came to the conclusion that there is nothing wrong in the third amendment. That is the operative portion. And no fundamental rights of the petitioners have been violated. Therefore, the amendment was accepted. Up to this, page 155. The respondent number 4 was given temporary current charge. That was done during the pendency of the WBC 92 of 2022, where the challenge to the third amendment was met. And during this time also, respondent number 4 was holding a post personal to the incumbent, and the substantive post is transfer officer, which is equivalent to undersecretary. By this order, under Rule 18, the Speaker has delegated the power of Secretary as temporary officiating charge of Secretary. And this was made subject to the outcome of WBC 92 of 2022, that is the challenge to the rules. But ultimately, challenge to the rules, that petition has been dismissed. So ultimately, I had to withdraw the case which was filed under current charge. This order was challenged by the petitioner in WBC number 144 of 2022, the current charge. In WBC 144 of 2022, interim order was passed on 22/7/2022, suspending the order of the temporary officiating current charge, but that came to be again vacated in IA 116 of 2022 by an order dated 12/8/2022. Against the vacation of the temporary interim order, temporary current charge. Because while vacating the interim order, the conclusion was that there is nothing wrong on the speaker to allow current charge. Okay, if it is only current charge, so that can be given. Then there is nothing wrong in that case. We waited. But then we challenge this. The vacation order has been challenged in April 28 of 2022. Against the vacation order, interim order was passed, that was vacated, so agreed by that, against the order passed in the interior application. We filed the writ appeal, and the writ appeal was decided on 3rd September 2024. Direction notes you will find in page 191, paragraph 16. Paragraph 15 will also be relevant because again, I don't read my learned friends will definitely read this portion. Page 191.
Para 15.
Because I want to be very clear. If I know, yes, Honorable Court may declare that what I am submitting is wrong. And if there is substance, then that can be accepted. Paragraph 15, page 191. Here, some observation has been made. I treat it as an arbitrary type because this observation was made in an IA where the issue was with regard to the temporary contract, allowing temporary contract, and in an IA. So the issue was on temporary contract, and it was an observation made in IM. Page paragraph 50. Having regard to the relevant provisions of the rules of 2022 for the filing of the post of secretary, Nagaland Legislative Assembly, it can be seen that us on today, the petitioner as well as the private respondents who are a contesting party are eligible to be considered for the said post. They are ignorant. The said posts are admittedly could not have been filled up on a regular basis during the pendency of WPC number 92 of 2022 in view of the challenge made to the rules of 2022. Therefore, to dwell upon the interpretation of Rule 18 of the rules of 1999 as amended and be examined as to whether the interim order dated 22/7/2022 was rightly vacated by the learned single judge in IA 116 of 2022 or otherwise, in our considered view, or only be an academic. This is also important, particularly having regard to the fact that the delegation of the private respondent is only temporary as spelled out in the Indian order dated 5/7/2022 itself. The order shall stand cancelled automatically on the day the appointment of the full-fledged secretary taken over charge. Now, the short pause here. In the appeal, Rule 18 was not an issue also. That is the discretionary power of the speaker. The issue in the Bill 828 of 22 is only about the current judge. Who should, whether it is ready to allow to grant that hold the current judge rule. That was the issue. Whether respondent number 4 is eligible to fill up the post on regular basis, the post of secretary, whether it is eligible or not, that is not decided. That was not the issue. That was not the issue. The bill was against an order passed in an IA. Therefore, in order to apply this judicata, there has to be the issue. Issue should have been determined. But any expression made during the course of discussion of the case can be at best treated as an arbitrary dictat. But ultimately, what is the direction? That is more important. What direction was issued? Can we come to paragraph 16? Same page 191, paragraph 16. We are therefore of the considered view that having regard to the temporary arrangement being made and at the same time the importance and necessity of having the post of secretary LLA to be made substantively by an eligible and qualified person as per the provisions of the service law, we are not inclined to interfere with the Indian order dated 12/8/2022. However, this is very important. However, we are of the considered view that there should be no further delay in filling out the post of secretary NLA on regular basis in accordance with law. So the ultimate finding of this the division bench was to fill up the post of secretary without further delay, that too in accordance with law. So what the law says will be important. What the law says for filling out the post of secretary. Who is eligible to be considered for a post of secretary? They have filled up that post after this statement. They have filled up the post on 6/3/2026. Very long time. The division bench order was passed on 12/8/2022, where it was said that there should be no further delay in filling up the post of secretary NLA on regular basis in accordance with law. Order was passed on 12/8/2022, but they have issued the order, first tribunal order, which they have modified. That was on 9/3/2026. Lordship will find at page 186. What order was first? Oh, before that, the earlier petition was filed. The withdrawal order, I would like to refer 193. In view of the order passed in the other case, this was withdrawn. Main petition challenging temporary officially current charge. And then can we come to page 196? Mr. Lordship, correct?
Yes.
9 March.
9 March 2026. In continuation of the Secretary's order number 5th July 2022, that is the current charge order, which Lordship will find at page 155. And in the interest of public service, the Governor of Nagaland is pleased to regularize the service of Srimati so-and-so in the pay scale of so-and-so and all other allowances as admissible under the rules from time to time with effect from 5th July 2022. 5th July 2022 is at page 155, by which the respondent number 4 was given temporary officially charge. And as I was mentioning earlier also, when temporary current charge was given on 5th July 2022, the respondent number 4 was still holding a post, the substantive post of transport officer, which is equivalent to the rank of minister. And she was holding an upgraded post pursuant to the incumbent on that day. So this was challenged. Here they are saying regularize. And the tribunal order which was passed on 25th March, they are saying promote. Sometimes they are saying regularize, sometimes they are saying promotion. They are not very clear what they are doing. Anyway, that was challenged in the DPC number 33 of 2026. Lordship will find it page 197. Order is there. And on that day, the consent for the respondent number 1, 2, and 3 appeared and sought for some time and wanted to place the records. This was on 26. On 26, and instructions the consent has been appeared. On that day, this 9 March, 25th March 2026 order was already there. But it was not disclosed before the announcement. On instructions, he entered appearance. Secretary is aware of the order. Speaker is aware of the order. On behalf of the Speaker, the Council is appearing. On behalf of the Secretary, the Council is appearing on instruction. And you are aware what order they have issued. Respondent number 4 has also received the order. But on 26 March 2026, it was not placed before the alarm call. And they wanted to produce the report. So order was passed accordingly. And next, a day before the matter was placed before the Honorable Court, the order was passed and again modified. 9 March 2026, order has been modified by order dated 25 March 2026. That is page 202. Annexure R. There is a vast difference between regularization and promotion. But the learned single judge has picked up the promotion and regularization. Was not very clear. May I read this order dated 25 March 2026. In supersession of the Secretariat Order number 9 March 2026 and in the interest of public service, the Governor of Nagaland is pleased to promote Srimati Dono Rio to the post of Secretary, Nagaland Legislative Assembly Secretariat in the base level of Somso, and all other allowances as admissible and rules from time to time with effect from 5th July 2022. That is the date of when the respondent number 4 was given the temporary current charge. And then since it was not in accordance with law, so it was challenged. But then, since other petition was there, where 9 March order was passed, that was withdrawn with the liberty to find that. That is in the law. And then the Indian law has been passed. Now, I would like to come to the rules. Page 206. This is an amended rule. Later on, this was amended by third amendment. When we come to page 209, rule 12. It talks about appointing authority. The secretary and additional secretary shall be appointed by the governor in consultation with the speaker. The appointment of all other posts shall be made by the speaker. This has been amended. The appointing authority has been amended that the secretary and additional secretary shall be appointed by the governor in consultation with the speaker, on the recommendation of the speaker, and in consultation with the chief minister. That is how it has been changed. And then can we come to rule 15, page 210. This is Departmental Promotion Committee. There is slight change, but the general principle has not been changed. For all cases of recruitment by promotion and selection, this is removed. For all cases, it includes secretary also. For all cases of recruitment by promotion and selection, there shall be a departmental promotion committee consisting of the following, and then the officers are shown. Here, the learned single judge was misguided on the ground that now the issue which is pending before the honorable court is pertaining to the post of secretary, and to consider to the post of secretary, it should be from the rank of additional secretary. Therefore, both secretary and the additional secretary will be out In which case, how officers in the level of joint secretary and below can consider the case of a higher officer. That is not possible. Therefore, Rule 12 is to be read separately to the exclusion of Rule 15. In other words, Rule 15 is inapplicable for promotion to the post of secretary. That was the submission made on behalf of Principal. But the answer lies in the rule itself, which the single judge has failed to take into consideration. Can we come to the last paragraph of the provision? Provided further that as and when the case of any of the members of the DVC is under consideration for promotion, he or she shall desist from attending the DVC meeting. See, the purpose of the proviso is that when any of the officers, when his or her case is to be considered, they have to desist themselves, request themselves that he cannot be a part to this.
DPC.
And the law is cited to the effect that for consideration of the post of secretary and additional secretary, only the junior officers cannot consider. There is nothing of that sort. And there is also nothing in the service law that for promotion to the post of secretary, Rule 15 will not be applicable, since it is a selection post. There is nothing in the Third Amendment has not taken away Rule 15, and Rule 15 says for all cases of promotion and selection. So, secretary is also important. Now, rule is cited about consideration of the case of a senior officers by junior officers. But there is single judge came to a conclusion that no, how officers below from the rank of secretary and others can consider DVC and consider the case of a higher officer. That is not possible. That was the argument, and the very single judge has accepted that. The solution lies here in the rule itself. That is what I am saying. And can they again come to Rule 22, which talks about the residuary powers. Relaxation in exceptional cases in the conditions of service, the power is given to the speaker and the Rule 19, but Rule 22 and 24 will be more relevant. Residuary powers. All matters, whether incidental or incidental to the provisions of this or otherwise, shall be regulated in accordance with such orders as the speaker may from time to time may. So, speaker has the residuary power. If the rule is silent, the speaker can appoint any other higher office, higher officer anyone from here or from anywhere as a
For a DPC.
for the DVC. Just because higher officers are considered, there can be no DVC. Can that be reasonable? In which case, Rule 15 will be written in that case. If we are read Rule 12 in isolation. And Rule 24 also, removal of difficulties. If any difficulty arises in giving effect to any of the provisions of these rules, the speaker may, by order in writing, specify as to what appears to him to be necessary for the purpose of removing the difficulty. So, the faced with the difficult situation, so speaker has every power to remove such difficulty. Why not in this case? Because for giving the current charge, for according current charge to the schooling number 4, by invoking Rule 18, the speaker has given exercise discretionary power that to run the assembly secretary smoothly. We need some officers, even in the current charge. In case of respondent number 4, it was very convenient and easy. For respondent, for a petitioner applicant, there is no way out. The door is always closed. So, and can we come to the secret? Because from time to time we'll be referring to this. page 221. Third schedule. Here, different carriers are shown in different columns. Third schedule, serial number 10, and then option will find in third schedule A. This is the general carrier. In extreme left, option will find secretary. And then in the extreme right, column 7. By promotion from additional secretary in a with minimum 2 years continuous service in a grade or as been filled. And then can we come to page 228. Third schedule D. This is where the respondent number starts. Lordship will find here in the extreme left, serial number 1 and 2. The respondent number 4 was appointed in the post of assistant transport officer. And the next promotional post is to the post of transport officer. And this transport officer is equivalent to undersecretary. Lordship will find in page 223 to show the equivalence. Page still is shown there under secretary under column 5 in page 223 and in column 4 also you will find pen pay, scale up pay, GB 6600 in the middle of the page on the top in page 223 and in page 228 pen pay 6600 in the middle of the page under column 4. So the transport officer is equivalent to undersecretary. And the respondent number 4 is holding a post under third schedule D, the transport officer. That is the substantive post she was holding before several accreditation, which was made personal to the government. In the amended rule, again, for better understanding, page 117, in the third schedule A, that is page 221 and page 117, maybe kept some mark for the daily because from 221 I will go to 117 and from 117 221 will be relevant. It talks about the third schedule A. Third amendment says under B, that is at page 117, in third schedule A, serial number 1, column 7, the following shall replace the existing entry. So in page 221, where I have shown column 1 and column 7, here in third page 117, in third schedule A, against serial number 1, column 7, the foreign shall replace the existing ministry. So the grade of additional secretary or equivalent in the rank of assembly secretary with a minimum of 2 years continuous service in the grade, if deemed fit by the amending authority. So the only addition in the third amendment is or equivalent as well in the. Therefore, since by third amendment they have inserted the word equivalent, they are claiming, respondents are claiming that since the word equivalent is there, I should be eligible because I am holding an equivalent post in the rank of additional secretary. But my condition is no. You are holding a post which is personal to the incumbent, and you are holding a subordinate post of transport officer, which is equivalent to the under secretary. All the conditions for personal to the incumbent. Personal to the incumbent. Therefore, there can be no interchangeability. It is not possible. We are not equal. I am holding a career post, and my promotion to the post of additional secretary is in accordance with law by TBC. And then the governors. But respondent number 4, TBC was not constituted. Without TBC, she was regularized firstly by 9 March 2026 order. Thereafter, when it was challenged, she changed the regularization order to the promotion order on 25th March 2026 as promotion order. That is why I was making a submission that sometimes they are saying regularization, sometimes they are saying promotion. That shows that they are still confused, in the state of confusement. Now I will, since I have referred to all the relevant documents, now only the finding where it has gone wrong, the learned single judge where it has gone wrong, I would like to refer to the judgment of the MUN order. Thereafter, I will conclude my submission. Page 28 is the MUN order. This was passed on 8 May 2026, but I will not trouble your lordship to go through the entire judgment because everything has been referred to all the relevant documents, and then the most part of the judgments are submissions. Here, my submissions have been recorded in 5 paragraphs, as many as in 5 paragraphs. Whether it is tenable or not, that is up to the relevant court. But my grievance is, I have submitted my case to the best of my ability, and the honorable court has recorded my submission in as many as 6 paragraphs. From paragraph 7 to paragraph 13 was my submission. Not even a single point was discussed by the single judge in the tribunal. That means my case was not taken into consideration at all. And the citations which I have placed before another court came to the conclusion that since the effects are not similar, so it is not necessary to take into consideration of the cited judgments. And that ground entire basis have been rejected, and only arrived the finding conclusion that the post of secretary is a selection post, and for that role 15 is not relevant. That is how the conclusion is denied. So decision you will find in page 42. Decision and discussion. So there is only 3 pages. Will it be necessary to read out all the judgments or
No. The relevant portion.
relevant portions? Then the rules have been extracted here in paragraph 27, page 43. At the relevant time, I will come if necessary And page 44, the rules has been reflected. From paragraph 29. Thus, the state government, this is also not correct. Nagaland Legislative Assembly is functioning under Article 187 of the Constitution of India. The Speaker has the power to make rules. It is not under the state government. Only retirement for the purpose of retirement, they are regulated by the Nagaland Retirement from Public Retirement Act. Otherwise, everything is a separate and separate establishment like that of the Lok Sabha chiefs. We are in from paragraph 29. Since there's only 3 pages. The state government, in its wisdom, by notification dated 18 May 2022, brought in third amendment to the 1999 rules, amongst others in third schedule A, against rule number 1, column 7. The following have been replaced by promotion from the grade of additional secretary or equivalent. Or equivalent is the only word that is inserted by the third amendment. In the assembly secretary with a minimum of 2 years of continuous service in the grade, if 10 feet by the appointing authority. It would be now relevant to refer to make a comparative rating of column 7 against rule number 1 of the third schedule. And then the chart is given 1999 rules, first amendment, second amendment, third amendment. So in the third amendment, in the external right column, under right hand side, the last column, in paragraph 30, or equivalent word is new edition. In the grade is another edition. That is for the post of secretary. Equivalent or equivalent or in the grade. Paragraph 31. With the aforesaid factual position, the learned counsel for the respondent number 1 to 3 and the learned counsel, senior counsel for the respondent number 4 have demonstrated that whatever the petitioner got promotion while remaining in general cadre, correspondingly, the post that the respondent number 4 was holding was upgraded to the post was made personal to the respondent number 4. All these were taken in the BBC 323 of 2021. Whether she is a cadre or not, whether she is equivalent or not, everything has been dealt with in the BBC. But again, ignoring that, the learned single dance has referred to all this. In continuation of 32, as per Rule 14 of the 1999 rules, corresponding to Rule 15 of 1999 rules, by third amendment rules, a DVC would consist of secretary, chairman, additional secretary member, joint secretary member, and the secretary member, member secretary, and the chief editor of debates, member for stenos. Therefore, it cannot be said that persons in the rank of additional secretary or lower than the additional secretary would consider the DVC for appointment of the secretary. Therefore, rule level of 1999 rules, the appointing authority for the post of secretary is the governor in consultation with the speaker. Correspondingly, under Rule 12 of the 1999 rules, as amended by third amendment rules, the secretary, additional secretary, shall be appointed by the governor under recommendation of the speaker in consultation with the chief minister. Therefore, the court is inclined to hold that the post of secretary is envisaged as a selection post. This is what I have been submitting motions, where the appointing authority is the governor, and therefore, for appointment to the post of secretary of Nagaland Legislative Assembly Secretary, no DVC is envisaged. This finding is contrary to the provisions of the service law, because third amendment has not taken away the requirement of Rule 15, that is DVC. No amendment, no way, the requirement of DVC has been done away with. And Rule 15 says, for all cases of promotions and secretary. So all will include even the secretary. Because in the rule, secretary and additional secretary will not be ignored. That is not mentioned in the rules. Therefore, Rule 15 is still surviving and alive under the rules. Even with the third amendment, it has not taken away. Therefore, from promotion to the post of secretary, ABC is a must, which they have not followed in this particular case. That is how we do. At least I need to make a change. And promotion to the post of additional secretary and head of the school. Even if it is very late, at least I will be. Now, paragraph 33. In view of the ratio laid down in the case of Hardeep Singh Sobra, the court is inclined to hold that if it is accepted that Rule 15 of the 1999 rules as amended by Third Amendment Rules 2022, then Rule 12 of the same rules will become redundant and outdated. If that is the case, then if Rule 12 applies, Rule 15 will again will be the same, redundant and outdated. Therefore, a statute is required to be read as a whole and not in isolation. The office of the Secretary in the Nagaland Legislative Assembly Secretariat is held to be in selection post, and the appointment is not based on the selection alone and can be filled up by way of selection from the grade of additional secretary or equivalent, subject to a minimum of 2 years continuous service and if deemed fit by the appointing authority. Thus, the said post of secretary is not required to be filled up by TVC. So the requirement of TVC has been done away with in order of the facts. In the light of the unique and facts and circumstances of this case, where by operation of 1999 rules, distinction made between the post held by the respondent number 4 and the post held by the petitioner, thereby placing the petitioner in the general category and the respondent number 4 in a category where there was no scope for promotion. The effect of Third Amendment of the 1999 rules being the petitioner and the respondent number 4 at part. The cases cited by the learned senior counsel for the petitioner is not found to apply under the distinct and unique facts and circumstances of the case, which is not found to be similar to the facts presented in the second case. Therefore, there is no necessity to discuss those cases laws in this order. In the light of the discussions, the court is unable to hold that the exercise of promoting the respondent number 4 by even notification 25/3/2026 is paid in law or facts. All this has been dealt with in the BBC 323 of 2021. And the direction of the division page in 382 of 2022 was also to consider the post for filling up the post of secretary in accordance with law. It's almost 5. I will take about 10 minutes to conclude my submission.
Okay, I add 2. Actually,
I'm doing the intelligence. In the morning, I mentioned item number 22, the last series item, by the other side for journal. Actually, there is an interim order, but I'm not in position to complete the interim order till the next.
okay, it will be continued.
Yes, the order will be passed.
It will continue. At 2, we'll meet again.
Sir, wait, Although our traditional is, I would not then.
Yes, yes.
My apologies for indulgence.
Mm.
It appears that the matter will be concluded today.
Mm.
And moreover, as per the post case,
Mm.
supplementary work to the key listed
Mm.
called first, and not only personal.
Mm.
Since the hearing has already begun.
Okay, now we will take the supply. You
For orders, item number 25.
Well, please, Lordship.
yes.
I want that the summons is for consultation of delay. My lord, there is a delay of 124 days.
More than 100 days. Today notice will go.
My lord, I am the caveator, Lordship. I have received a copy of the alia.
Or you are a caveator.
Yes, yes. Now, I will find an objection to the
Okay, all right.
IA organization.
Okay.
2 weeks and.
Who filed this petition? State file.
Yes.
Hard Mr. So-and-so did land public prosecutor appearing for the applicant. Hard Mr.
Easy problem.
Appearing for the
Still.
opposite party.
Yes. Lordship.
The learned counsel for the opposite party prays for some time to file an objection.
Yes, sir.
His prayer is allowed least after 3 weeks.
2 weeks, sir.
2 weeks.
Much more.
Very heavy.
Item number 26.
Yes.
On behalf of the applicant.
Yes.
Lordship, this is an application seeking urgent and interim application. Pending the accompanying writ application of 1526. My lord, the accompanying writ application has been filed along with condemnation of delay.
Hmm.
This honorable court was pleased to issue notice for accommodation application on 24/06/2026, and therefore the respondents are fully aware that the matter is presently pending before this honorable court. At present, Your Worship, the applicants are being faced with imminent threat of coercive action on 6/07/2026. Revenue officers accompanied by Wazis visited the residential premises of the applicants and already directed them to vacate the residential house within 2 days, telling which the structure would become demolished. Your Worship, immediately the applicant approached the commissioner by way of written representation dated 06/07/2026, requesting that no irreversible action be taken pending consideration of the appeal. The application also approached the registrar on 07/07/2026 for urgent listening and thereafter additional representation dated 07/07/2026 was forwarded to the Deputy Commissioner.
Urgent intervention is not possible.
Your Worship, if you kindly
Notice is issued already. There is the appeal admitted.
In the condemnation petition,
yes.
notice.
But we are yet to be served extra copies for our condemnation.
Oh, so, oh, you have received.
When the appeal is not even admitted.
Not a, delay has not been condoned.
Delay has not been condoned. How can we?
No.
Your Worship,
Okay, you filed an objection earlier date. In the IA number 136 of 2026. Heard Mr. So-and-so appearing for the applicant. Heard Mr. So-and-so appearing for the respondent number
1
1 to 5. 1 to 5. The learned counsel for the respondents has submitted that he is yet to receive the copy of what?
Extra copies.
Extra copies for the condemnation and the lordship were yet to receive, to be served.
He has not
IA
yet
151.
received the copy of this petition as well as the petition filed in IA number 151 of 2026. The respondent shall be given copies of those two applications and list the matter again on 28th July.
That's true.
List is finished, no?
To continue hearing item number 19.
Yes. We will continue with the hearing now. Yes, please continue.
Particularly, most
Yes, yes.
lateral portion. Only to summarize
Yes.
few points, will take about 10 minutes time only. Firstly, since the subject matter involves equivalence of force, so whether this can be decided when it is already decided by the non-court. So the Gator issue has already been decided in the WPC number 323 of 2021. By judgment and order dated 15/5/2022. That is annexed at page 82. The respondent number 4 is not in the Gator. Therefore, we are not equivalent. After the decision was passed on 12/5/2022, there is no order of observing respondent number 4. There is no such order. There is no regularization order also, without the engine order. Therefore, she was holding a post on the strength of order dated 30th November 2019. That was the last order. And she was holding a non-cadre post. A post upgraded personal to the incumbent. Otherwise, on the day of assuming granting current charge on 5th July 2022, she was holding this post only on the strength of 30th November 2019 order, which is an upgraded post pursuant to the incumbent with the condition it will be reverted back to the post of transport officer. So she was holding the substantive post of transport officer equivalent to the undersecretary. Therefore, we are not equivalent. But the learned single judge has treated as if the respondent number 4 is eligible and equivalent with the petitioner. She is not engaged and we are not equivalent. That is number 1. Number 2 point. A non-cadre officer cannot be treated as a cadre officer. We were treated at par by the learned single judge. But a non-cadre officer cannot be treated at par by the cadre officer. Therefore, respondent number 4 was not holding a cadre post. These are all, even the paragraphs in the judgment, between judgment. I have the paragraphs with me. With regard to Rule 15, it appears little misguided. The learned single judge has been little misguided on Rule 15 and wrongly held that the new DPC is required for consideration for a post of secretary. Rule 15 has never been removed from the service rule by any amendment. Therefore, for the promotion to the post of secretary, Rule 15 is relevant. The finding of learned single judge to the effect that no DVC is required for consideration of promotion to the post of secretary is contrary to the rules, because Rule 15 has never been removed. Nowhere in the service rule describe that the post of secretary is a selection post. This point, the post of secretary is a selection point, has been argued at the time of hearing the case, and the learned single judge was convinced that, oh yes, this post of secretary is a selection post, therefore we will be system. This is how the question was, right? But nowhere in the service rule it is described that the post of secretary is a selection post. Rule do not say this, that it is a selection post. Therefore, TBC is required to be considered. And another point, the service rule has not said anything to ignore the seniority and the TBC. Had there been some provision in the service rule that seniority cannot be considered for consideration of promotion to the post of secretary, and no DBC is required for consideration of the post of secretary. There is nothing in the service rule. So when there is no provision in the service rule that DBC will not be required for the post of secretary, how the learned single judge has arrived to the conclusion? When the service rule doesn't say anything about this. Therefore, the inquiry judgment is liable to be interpreted with. And Lordship will find by reading the Rule 15, the word study in the Rule 15 is for all cases of promotion and selection. It is mentioned. It doesn't exclude the second post of secretary for all cases. And service is defined under the rules. What is meant by service? So the post of secretary is included among the all cases. But then the single judge has treated as if Rule 15 has mentioned that it will not be required. Therefore, the finding of learned single judge is not sustainable. Learned single judge has arrived to a finding that Rule 12 of the rule can be independently applied. In other words, Rule 15 will not be applied. It is only Rule 12 which can be applied. But both Rule 15 and 12 will be applied simultaneously for different purposes. How? Under Rule 15, DBC will consider and they will consider the cases for promotion and DBC will send recommendation. They are only the recommending body. They will recommend who should be considered for promotion. And based on the recommendation of the DBC, the appointing authority under Rule 12 will appoint any person. Therefore, the third amendment has not made these two rules different, and one should be applied, one should not be applied. Third amendment has not said no. The main rule of 1999, 2012 rules doesn't say about this. And the immune order dated 25/3/2026, which Lordships will find in page 202, is not on deputation nor on contract appointment. It is a promotion. It is a promotion. Therefore, Rule 15 is attractive for consideration of promotion to the post of secretary. It is not a deputation or on contract. It is a promotion. Therefore, as contemplated in the service rule, that DBC is a must for consideration of case of the secretary. Next point. While deciding Writ Appeal 28 of 2026 by judgment and order dated 3/9/2024, this honorable court, that is the division bench, has directed to act in accordance with the provisions of the statute, in accordance with law. It has not given any direction. No doubt, during the discussion, so many expressions have been made, but those expressions can be treated as an obiter dicta, not a finding, because the issue in Writ Appeal 82 of 2022 is with regard to the current charge. And the Writ Appeal is in an IA against rejection of the interim order. Therefore, no issues have been determined. On the eligibility, no issue has been determined. Therefore, the principles of res judicata will not be applied, and altogether, this judgment of 3/9/2024 is altogether on a different line, which has nothing to do with the decision, which has nothing to do to decide the eligibility of petitioner and the respondent report. It only says decide in accordance with law. So what the law says will be relevant now again. I'm coming again and again because this is a fourth law. where what the law says has to be said. Not that what I say, what he say, what is the invigilation of someone else. That is not important, but what law says is important. Therefore, in Writ Appeal 28 of 2024, no issues on eligibility has been said. And then no determination, not determine the issue of eligibility in Writ Appeal 28 of 2024. Therefore, the principle of this treaty will not be applicable. Because respondents may say that, no, during the hearing of Writ Appeal 28 of 2022, the division bench has observed in this manner that those are all omitted there. As I have submitted, issue assembly. Another very important point which the learned single judge has misapplied is, with due respect, in order to decide and defend the case of the petitioner, the learned single judge has relied in the case of Hardeep Singh. But then, to say that law has to be harmoniously construed, that means both Rule 12 and 15, actually it should be construed harmoniously going by his finding. But in a different light, the learned single judge has decided. I will refer to only two paragraphs in Hardeep Singh's case, paragraph 42 and 44. Once the learned single judge examined these two paragraphs, the finding would have been different. That means it is a well-settled principle of law that the statutes are to be construed harmoniously. Correct. That is the correct principle of law. And we wonder, while applying Rule 12, Rule 15 should also be applied harmoniously. TBC will consider recommendation will say under Rule 12 it will be appointed. Not that only Rule 12 is relevant and only this will be applied, other provisions of the rule should be ignored. Therefore, the reasoning and the finding of learned single judge doesn't tally with what the normal court wants to see. So it has to be harmoniously construed. But it was not harmoniously construed. Only Rule 12 should be read in isolation. That is happening. Therefore, a difference on this normal court is required. If the respondents are saying that respondent number 4 is equivalent with the petitioner, let them show from some order of the authority that by this order, by this promotion, by this absorption, by this regularization, I am equal to the petitioner. Let them say, through some orders, but then there is no order as such. Therefore, the entire basis of the finding of the learned single judge is required to be indifferent with by this honorable court. And some important points on the division bench judgments. Because as I said, there are two division bench judgments. One is on the current charge issue, and the other is challenge to the provisions of the service law, third amendment of the rules. So on these 2 points, my submission is on these 2 division bench judgments from this, what right has been conferred to respondent number 4 by the third amendment of 18/5/2022. My responsible submission is no right has been conferred on respondent number 4 by third amendment. Secondly, whether the 2 judgments have laid down the law that the third amendment has conferred the right to respondent number 4. Both the cases are recognized as I have already submitted, so they may not repeat. And there was no cause of action arose to challenge Rule 12 while challenging the Third Amendment Act by the association. There was no occasion to challenge Rule 12 because the whole case in challenging the amendment is the respondent number 4 was forced to be brought to the gathering, which the association members did not want. And next point, in none of the judgments in the two disciplinary judgments, in none of the judgments, it is decided that respondent number 4 is holding a career post. And that is how the respondent number 4 has become equivalent with the writ petition. There is no finding on that specific one. With regard to the getter of the respondent number 4, except the judgment of 12/5/2022 in the BBC 323 of 2021, except that judgment, nowhere, either in the division bench nor in the single before the single judge, it has decided the getter issue of respondent number. Therefore, this honorable court is to decide her eligibility in these proceedings in terms of Rule 12. Whether the Third Amendment has created the right to the employees. Third Amendment has conferred right to the employees who are holding equivalent posts. Those officers can be considered. But so and so should be considered, so and so should not be considered. It is not said in the Third Amendment. But the fact remains, Third Amendment has conferred a right to the employees who are holding substantive posts in the equivalent post. For them, right has been conferred so that they can be interchangeable and they can be considered for promotion if they are holding sanctioned posts. In other words, substantive posts in accordance with the rules. Therefore, that particular post has to be one of the cadre posts and one of the sanctioned posts in the service role. And if the respondents are not in a position to show that I'm holding this sanctioned post, I'm holding this substantive post, and because of this, I'm equivalent with the writ petitioner ability. And if they fail to show that, she is not equivalent. And who are holding the cadre post can be demonstrated from the service rules, because in the schedule, different category of posts are shown. Who can be promoted to grade. So, the entire objective of the respondents is they have intended well to bring the respondent number 4 to the cadre, but it has to work out very poorly. They have taken the blame from the employees by trying to bring her, but and they thought that the service of permits gives her a right to come to the camp, but there is no order as such bringing her to the cadre. Therefore, she is not equivalent with the writ petitioner, and she is not fit to be considered for promotion to the post of secretary. Therefore, the entire action of the respondents are not in accordance with law, and therefore liable to be interfered with. The learned single judge has come beyond the provisions of the service rule and not in terms of the service rule, the finding has been reviewed. Therefore, the judgment of learned single judge is liable to be interfered with by this number. I'm grateful for the patient hearing. With that, let me conclude, and then after the submission of my learned friends for the respondents, I will give a short reply. Any advice?
Yes.
Mary's lordship, which I'm looking for is number one, picture. Now. Lordship, by filing the connected writ petition, worthy of 2026. The appellant petition had challenged the order dated 25/3/2026, promoting the responsible for the post of secretary in the Nagaland Legislative Assembly. Now, for the grounds of challenge, may I take the lordship to the pleading? Relevant paragraph 19, page 67. Here's the repetition, the ground for challenge. Mainly on two grounds. Lordship has got it, paragraph 19. That the petitioner begs to state that the service condition of employees of the null as well as only is governed by the service rules and such as capital practice. And the relevant rule to decide the present case is Rule 15, which prescribes that the recruitment by promotion and selection service done by the DPC. Here is the first ground. The second ground is paragraph 21. That the petitioner respectively submits that she was promoted to the post of additional secretary on this. As per the applicable service rule, the next promotional post is that of secretary, for which a minimum of 2 years service in the rank of additional secretary. But accordingly, the petitioner did not eligible for consideration for promotion to the post of secretary, well before the prior respondent for. And next is very relevant. In contrast, the private respondent number 4 became eligible. This is their statement for consideration only with effect from 18/5/2022, that is upon the amendment of service rules by which she was brought into place on the consideration. Despite this, the MP notification not only violates the prescribed service rule, but also lawfully deprives the petitioner being the senior most eligible officer of a rightful consideration for promotion to the post of secretary. Regarding eligibility criteria, whether the respondent was holding a substantive post or the medical post holder she was eligible for promotion to be considered for promotion to the post of secretary, there was not an issue because that was not disputed. When the petitioner himself admitted that she is eligible, but with effort from 18/5/2022, then it was not necessary for the earlier proceeding to make different issue on the eligibility. So the grounds for challenge in the petition was firstly that the promotion responsible for was given without a consideration is the cause of the one. Second, the petitioner, though she is the Shilamos, has been deprived of a rightful consideration for promotion to the post of secretary. Those are making the two grounds. Now, petitioner has just now, that is taking that usual from the statement back to the petition of pleadings. And appellant is not very pleading. On eligible criteria, there is no dispute. So the issue is not necessary to go into that issue, further issue. Now, coming to the prayer. Here, page 72. Prayer 1 will be that to provide a notification to direct the response office to constitute this for delivery of permission. Now, as regards the second issue, the petitioner on the ground taken is that though she is the senior, she is being deprived of being considered for promotion to the police secretary. That has been already decided, examined and decided in earlier litigation. So the only issue for consideration before the in petition 40 of 2026 was whether for the post of promotion for filling up the post of secretary in the Nagaland Legislative Assembly Secretary, whether Rule 12 will apply or Rule 14. I rest your submission. That was the only issue before the Independence Gentlemen. Now, I'll confine myself to Rule 7. Now, apart from Rule 12 and Rule 13, the Learned General Council has referred to the lordship to Rule 22 and Rule 24 of the Service Rule, which provides for power in the election rules or the removal voting of difficulties. But in my submission, when there is provision made in the Service Rule for filling up the place of secretary, the question of exercising power under Rule 22 or 24 for relaxation or removal difficulty does not arise. So my submission will be confined to Rule 12 and Rule 15. Yeah, I think your worship will be what? There is page 116. There is a black column. Rule 12, your worship has to be read with church schedule 8. Column 5, page 116, column 1, Rule 12. Under the caption appointing authority, the existing sub-rule 1 is replaced by the following. Rule 12, sub-rule 1. The secretary and additional secretary shall be appointed by the governor on the recommendation of the speaker in consultation with the chief minister. Now, may I take your worship to next page, that is the church schedule, which is amended. In church schedule A against serial number 1, column 7, this relates to the post of secretary. The following shall be replaced by the existing entry. By promotion from the grade of additional secretary or equivalent, it does not say that it must be a substitute post or the assembly secretary with a minimum of 2 years continuous service to the grade if deemed fit by an appointing authority. Now, just because the officer has the minimum qualifying level of service, that will not give him a right to be promoted, but it must, he or she must be deemed fit by the appointing authority. And Rule 12, sub-rule 1 says the appointing authority is the governor. Now, but then may I take your worship to Rule 15. I'll come back to Rule 12 again, but now Rule 15. What does Rule 15 says? 212. Page 212. In the principal rule 210, your worship is volume. In the principal rule, it is Rule 14, but renumbered as Rule 15. This. For all cases of recruitment by promotion, now before that, may I take your worship to 209? 209, Rule 12. Rule 12, sub-rule 1 has been amended. 2 is there. Worship has got it. 2 is there. Appointment to all other posts shall be made by the speaker. In other words, so far as
for the post of secretary and additional secretary, a different procedure is provided for appointment. Appointing authority is different, that is the governor. But for other posts, the appointing authority is the speaker. So appointment to all posts, other posts shall be made by the speaker. Now, how is the speaker going to make the appointment? For that, no procedure has been laid down. Whereas for appointment to the post of, for filling up the post of secretary and additional secretary, the procedure has been laid down. Appointment to the governor. He will make it under a combination of in consultation with the chief minister. Procedure is laid down. But for other posts, no procedure has been laid down. So, Rule 15 comes from play. So that has to be by way of this. Now, may I take your worship to Rule 15? For all cases of employment by promotion and selection, there shall be a DPC consisting of following secretary, chairman, additional secretary, member, joint secretary, member, deputy secretary, under secretary, all of members and members there. Provided that the service report of the eligible officer in the form of consultation shall be completed on the basis of the annual contribution report for preceding 5 years. Provided further that as and when the case of any, the Learned Senior Council has read this as officers, but not officers. Any members of the TPC, not officers, is under consideration for promotion, he or she shall desist from attending the TPC. Now, who are the members? Members are the additional secretary, joint secretary, deputy secretary, under secretary, not officers. So, when any member of the TPC is under consideration, in other words, secretary cannot be replaced. Secretary has to be chairman. Without secretary as chairman, there cannot be replaced. Now, under the given facts and circumstances, if promotion is to be made for filling up the post of secretary to be made to DPC as present, we is the case of the petitioner promotion. Now, Lordship may imagine this thing. The member constituting the DPC for promotion to the post of secretary will be joint secretary, deputy secretary, under secretary, because additional secretary being the zone of consideration as per the provider, she cannot be a member, no, she cannot be a member. So all junior officers will be sitting as member of the DPC. They assess the performance of a senior officer and make the recommendation. And that is why I have made a submission before the Learned Civil Judge. In my research studies, I have never come across, heard of DPC, which is comprising of all junior members of its assisting as the performance of senior officer and making the recommending their name for promotion. So, in my respectful submission, the DPC contemplated under section 13 of the series is not for the post of secretary. A special provision has been made for filling up the post of secretary and additional secretary in the secretary. Now, may I take your worship again to Rule 116, page 116. By this, column 5, by third amendment, only sub-rule 1 has been amended. And the procedural provision is exhaustive. The secretary and additional secretary shall be appointed by the governor on the recommendation of the speaker in consultation with the chief minister. And whereas the third schedule
Next page, 17, who are eligible to be considered for promotion, but promotion from the grade of additional secretary or equivalent in the assembly secretary with minimum of 2 years continuous service on the grade if deemed fit by that Kohima or 20. So there is not especially by way of promotion, but by way of selection. Because it can be not even by way of deputation, because as per the Roshi mechanism, parliamentary group 9 be replaced as follows. Page 115. Roshi has got parliamentary page 215. This is the third amendment modification. Recruitment to the post or class of post may be made by anyone of the following representing promotion, deputation, direct recruitment, short-term contract agreement. And here, the threshold aid by the provision is not if it is exclusively by way of promotion, that it must be promoted from additional secretary. But anyone who's holding equivalent post in the assembly secretary with 2 years minimum continuous service. So it is a selection. And that has been already decided in the in earlier proceedings, litigations by this court. So in my respectful submission, Rule 12, Sub-Rule 1 is an exhaustive provision governing the procedure for appointment or fulfilling of the post of secretary in the assembly secretary. Accordingly, as on Rule 4, in terms of the direction passed by the division of this by the division bench of this on the court, to fill up the post as per law in terms of the rules. So strictly in consequence with Rule 12, Sub-Rule 1, read which Procedure A, the responsible for the post of secretary by the order dated 25/3/26 change. By that additional. Therefore, the letter single class has rightly held that proposal of secretary is not interpreted enough. May I take your worship to page 46? Page 46, paragraph 32, last line, there is the finding. Worship has got it. As per Rule 14, as I said, Rule 14 of 1999, this is the principal rule. Subsequently, it is renumbered as Rule 15. Corresponding to Rule 15 of the 1999 rules as amended by third amendment, a DPC will consist of this additional secretary, this. Therefore, it cannot be envisaged that a person in the rank of additional secretary or lower than additional secretary would constitute a DPC for appointment of the secretary. Therefore, under Rule 11 of the Rule 1999 rules, that appointment for the post of secretary, now renumbered as Rule 12, is the governor in consultation with the speaker. Correspondingly, under Rule 12 of the 1999 rules, as amended by third amendment rules, the secretary, the additional secretary, shall be appointed by the governor on recommendation of the speaker in consultation with the chief justice. Therefore, the court is inclined to think that the post of secretary is ambitious as a selection post further appointing of the governor, and therefore, for appointment to the post of secretary of Nagaland as the assembly secretary, no this case. So this is regarding applicability of the rules. Rule 12, not Rule 13. Now on the second block that has been which was taken into the petition as a petitioner, in this no she has been declared impossible for promotion to the post of secretary. This issue has been already decided in earlier proceeding. May I take your lordship to page
165. Now just read out the relevant portion. 165. Lordship required. There is an order dated 12/3/2022 in IS 116 of 2022, arising out of petition 144. Yes, relevant page 179. Last paragraph. May I read out? The third amendment, which is under challenge in the petition 92 of 2022, has no doubt reorganized the service of the employees, the assembly secretary, especially from joint secretary to secretary, and that has brought the service of the applicant in the general category, and as the applicant here in the IA is responsible. And that is matter eligible for promotion to the post of secretary. As per clause 5 of the third amendment, the secretary of the assembly secretary is to be appointed by the governor, which I already referred to, on the recommendation of the speaker in consultation with the chief minister. And as per clause 7b of the amendment, the post of secretary is to be filled up by promotion from the grade of additional secretary or equivalent. This is the third schedule A in the assembly secretary with a minimum of 2 years continuous service in the grade, if deemed fit by the appointing authority. The word if deemed fit by the appointing authority makes it amply clear that promotion to the post of secretary to the assembly secretary is by selection and not by seniority. Therefore, delegation of charge of secretary to any of the senior most officers will on yes. Now here, the Learned Senior Council has tried to impress upon your lordship by saying that in this only and for the people because there is an order of asking and did. But here, the issue for determination whether the petitioner do claim herself to be the senior is to be as a right to be considered in charge of the post of secretary. That was the issue. So here the question. Now, it is not for filling on the post of secretary, it is not based on seniority in this selection. So this finding, in my responsibility is coming wrong. This is a finding by us that the post of secretary is not a promotion post, but a selection post. Now, against this finding, no evidence by the people that are petitioner. So this is it's final. Now, according to your lordship, the paragraph 32, page 47 of the Indian on just 11 portion of page 47. Even the learned civil judge has arrived at the same finding. Para 47, that will be the fifth line from the bottom of para 32. This is just continuation of para 32. The fifth line from the bottom. Therefore, lordship has got therefore, the court is inclined to hold that the post of secretary is as a selection. These are the findings, no? So when it comes to in maturity, when it post is based on selection, it is not on seniority. And therefore, the condition of the petitioner is grounds for challenge. For the Indian order 25/3/2026 by the petitioner before the learned civil judge on the ground that though she is the senior most, she has been denied of a right to be considered for promotion of post to secretary is not sustainable. Now, if your lordship mechanism go to order dated 25/2026. By that order, I have been directed to produce the report. The order is dated 25/2026, by which I have been directed to produce a report. And the report will speak for itself that the promotion of the responsible for the interim order dated 25/2026 has been issued in conformity with the direction passed by the Honorable Division Bench.
Copy.
I will just read out the relevant portion. Yes. It's It is subject promotion to the post of secretary. Nagaland District Assembly Secretary. Motion is put in that. I'll read from the middle. After Rule 12 in Italy, after that, they are only. The Nagaland District Assembly Secretary had no full-fledged secretary after the resignation of former principal secretary Dr. such and such with effect from such and such. Subsequently, Srimati such and such is responsible for additional secretary. Transport was dismissed as secretary in charge and LA secretary with effect from this by Honorable Speaker as per the rules stated above on official basis as a temporary measure for the good administration and smooth functioning of the secretary. Therefore, the vacant post of secretary is now felt necessary to move for filling up the post. In fact, there are two incumbents in the zone of promotion for filling up the post of secretary. And again, Simon is like there is the relevant petitioner and the respondent for. Now, number one, the petitioner. That was promoted to the post of additional secretary with effect from this, took charge of secretary for a period of 1 month with effect from this to this. Second, the responsible for was promoted to the post of additional secretary transport with effect from this, took charge of secretary on temporary basis for a period of 3 years and 4 months with effect from this till date. The following documents are enclosed for purpose of one, the service rules, two, the CD. Number three, notification for promotion for such and such submitted for plan proposal. This is being processed by the Joint Secretary MLA and addressed to the Honorable Speaker. Now, next page. There's the noting of the Honorable Speaker. As indicated, all relevant documents enclosed here have been examined thoroughly. Moreover, both the additional secretaries have been given full opportunities in service of the NLA and also their service office. I therefore, after careful deliberation and in accordance with the rules and conditional service such and such, recommend that is responsible for to be promoted and fill up the vacancy of secretary in the NLA. The post of secretary is lying vacant since such and such. I also recommend, given the case of the petitioner, appellant that the case of Srimati such and such be appointed as secretary pursuant to the incumbent through the creation code of the secretary in consequence to the use of such. In this regard, Honorable Chief Minister is referred to kindly company in the government to Honorable Government for place. The speaker. Next is the noting of the Chief Minister. The case of Srimati such and such may be considered for promotion to the vacant post secretary such and such. Approved for Honorable President is now next is approved as proposed by CM. So strictly in consonance with the procedure, the provision of Rule 12. The case of the responsible for, in fact, both the PT diagram and responsible for the case, and then the case of the responsible for was
in the appointing entity has been forgiven. So the issue about the person before the rules of Senate. Now I have a question. The London Senior Council has advanced a submission that Rule 12 and Rule 15 should be read harmoniously. And his interpretation is the DPC will consider recommend. That is how he has interpreted harmoniously. DPC will consider the case of those who are within the zone of promotion recommended, and then 12 will come into play. The speaker will recommend again. So, above the recommendation of DPC, if the interpretation of the London Council is taken, then again, the speaker will again recommend above the recommendation made by the DPC in consultation with the chief minister. And then the appointing authority will be the governor, and the governor will appoint if he deems fit. That is not how, once DPC recommends, the appointing authority make the appointment on the basis of the recommendation of the DPC. So how many in hard to say? It is that those provisions must the statute must be read as a whole, and then every provision must be read harmoniously, so that in while interpreting one provision, another provision is not met with them purpose. That is the Indian, that is how the laws we go. That is what paragraph of law says. And rightly so, if the letter single justice that no. If when you work explicitly provides for the manner, the appointing authority and the procedure as to how the post of secretary is to be filled up, when Rule 12 provides the same. Now, if secretary is to be appointed as provided under Rule 15, then Rule 12 will become redundant. So, a harmonious statute to be read as a whole, give harmonious construction so that none of the provision in the statute is not different. And the London City Justice and has decided, as per the principle that offered on the as for the 100%. So there is no need for the in the manner in which the London City Justice is interpreted what that it is Rule 12 which applies for setting up the post of secretary. That's something secretary can do. So it matters to put some nation on motion. The simply judgment now, the law, but is just for non safety, so I guess the well civil no, which goes for into in especially in interval activity. And when it comes to interference in interval appeal, I'm not sure. Many and 2025, 50, 2025, so 7 years, 2025, 7 years, 50. Para 15, yes. 50. 2025, volume 7 deals with page 531, para 15 and 16. May I know?
What is the party's name?
The party's name, Sofika Hussain
Oh,
Ara Begum,
Yes. Para?
para 15 and 16.
Yes.
It may be mentioned that in the case of Starline agency such and such, this court has held that if two reasonable and logical views are possible, the view adopted by the single judge should normally be allowed to appeal. 16. In the same context, we will also refer to the decision of this court in the case of tractor and farm limiter such and such, which was followed in the case of such and such. In my respectful submission, Your Worship, in the present case, even that two view is not. When it comes to applicability of the rules or filling up the post of secretary, whether rule 12 or rule 15 will apply, it is rule 12, rule 15 will not. So in this, in the present case, Your Worship, the two pieces of next case, Your Worship, 2020, volume 16, SSL. Para page 478, 2020, volume 16, SSL, page 478, para 44. Further, in such and such, while considering the scope of the intra-court appeal, I guess like this, please, this court has held, unless the appellate bench concludes that the finding of the elder single judge are reversed, which shall not disturb the same. So in my respectful submission, the judgment order under challenge does not suffer from any proceeding which calls for interference by the submission. Therefore, in my respectful submission, the appeal is liable to be dismissed. I conclude with much obligation.
Mr. Lordships. Lordships, since it is subject to senior counsel for appellant that come in facts of the case, and this is the 8th round of litigations. It is quite probable that the case will be finally decided on the 9th round. 9 is a powerful number. Now, my lord, I need to go into the facts of the case to founder the submission of the counsel. Because I would like to satisfy the lordship that the principle of constructive rest will be applies and not to, except for which rule to apply. Whether rule 12 or 15 will apply. Besides that issue, which my other friend has already dealt authoritatively, which I will not begin and obtain his view. But then other issues is already covered by the principle of res judicata. So I will be going through the previous judgments to show what was the starting submission of the constitutional appellants and how the issue of eligibility, substantive points besides the statements and other related to selection board or division boards. All that has already been decided by the previous round of application. So I would like to refer to the 11 paragraphs of the previous round of application to satisfy your lordship. Now, my lord, I will take at this 1 hour to conclude my submission. And then definitely my learned friend also would like to file we also like to finish this line. So whether if this honorable court is agreeable, we can continue the division there. If indulge, we can continue this bench tomorrow, so that we can conclude the matter, or I continue hearing so that we escape. If we continue, resume at 2. If we resume at 2, then the second half, so
Tomorrow,
that by in the first half, we lordship take up single bench and who will
tomorrow at 2, we'll continue.
continue.
Lordship, if the condition is late, up to the part 1 matters. Sometimes part 1 matters may
No, take
be
some.
ready. Or it will be better if TP is considered first, thereafter a single bench can constitute.
That can also be done. DB in the morning. In the morning, 10:30
That's
DB.
better.
We are highly objection, so that there is no break in the hearing.
Oh, yes.
I mean, I came, I.
Okay, tomorrow at 10:30.
I got your expected.
We are very much. Us at a sleepless night watching the World Cup.
Watching World Cup.
So it's a very one take.
Yes, yes.
And for reading purposes, sometimes it comes blurred.
Yeah.
We are also getting our ears as well, so it's just taking out.
Okay, then. Let's ask some more. Tomorrow at 10:30. Release this matter
As part,
tomorrow at 10:30
as part.
as part heard.
Okay.
Okay.